Hi guys, welcome to another episode of Atty. Vlogger, Law for the Everyday Layman. Today we'll take up part 9 on the law of obligations and we talk about the joint and solidary obligations. So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice. Now, before we begin with joint and solidary obligations, I just want to emphasize that there is a difference between individual obligations and collective obligations, okay? In individual obligations, there is no problem, no? There's only one creditor and one debtor, and we just apply the rules which we have learned, okay? But in collective obligations, there may be 2 or more creditors or 2 or more debtors, in which case you will be applying the rules that we will discuss, okay? Now, just because there are 2 or more creditors or 2 or more debtors does not mean that any of the creditors can demand that the obligation be fully complied with, okay? It also does not mean that any of the debtors has to pay the full amount, okay? Because the obligation is presumed to be joint. In other words, the obligation will be fulfilled proportionately by the debtors, okay? Each debtor is only liable for his share, and each creditor is only entitled to demand his proportionate share, okay? In other words, the credit or the debt is presumed to be divided into as many equal shares as there are creditors or debtors, and the credits or the debts are distinct from each other, meaning they stand alone and do not affect the other, okay? Now, as for solidary obligations, which refer to obligations where any of the solidary creditors may demand full or entire compliance with the obligation, and any of the debtors may extinguish the obligation by fully paying the amount due, no? In that case, there is only solidarity, or an obligation will only be solidary in any of the 3 cases, okay? First, when the parties so expressly declare, okay? The parties have to say expressly that we are being bound solidarily under this obligation. Second case is when the nature of the obligation so requires. And third, when the law so requires, no? If the law says that the liability of the parties is solidary, then there is also solidarity, okay? So solidarity again only exists in those 3 cases, and if those 3 cases are not present, then the obligation is presumed to be joint, especially when the obligation is silent, okay? If there is nothing said about the liability of the parties, then it is presumed to be joint, and each debtor is only liable for his proportionate share. Each creditor can only demand compliance for his proportionate share, okay? Again, in a joint obligation, each creditor is entitled only to his share, and each debtor is only responsible for his own share. Now, as to joint obligations, the sharing of the parties is presumed equal. Okay, but that is only a presumption. It may so happen that the parties may have bound themselves differently. Okay, in other words, X may have bound himself to pay only for 1/4 of the debt, and Y may have bound himself to pay only for 3/4. Okay, in which case X cannot be compelled to pay more than 1/4, and Y cannot be compelled to pay more than 3/4. Okay, let's give some more examples. Let's say X, Y, and Z bound themselves to pay 12,000 pesos to A and B. How many obligations are there? There are 6, okay? X has to pay A 2,000, X has to pay B 2,000, Y has to pay A 2,000, Y to B 2,000, Z to A 2,000, and Z to B 2,000. So there are 6 obligations here because it is the debt of 12,000 is divided amongst the parties, okay? Now, what if ABC bound themselves to pay 9,000 pesos to X, Y, and Z? Okay? If X, Y, and Z proceed against A alone, they cannot ask for the full amount because A is only liable for his debt, okay? So, how much can XYZ ask from A? Only his share, which is 3,000. In other words, 9,000 divided by ABC. So that's 3,000. Okay? And now that XYZ have gotten the 3,000, they will now divide that amongst themselves. They get 1,000 each. Okay? What if X alone is the one who goes after A, B, and C together? Can he get the whole debt? No. Okay? He can just get what the share he is entitled to. As a creditor, he's only entitled to 3,000 because XYZ as creditors have to divide the whole debt of 9,000 amongst themselves. No? There are 3 of them. So each creditor is only entitled to 3,000. Okay? So he can get 1,000 from A, 1,000 from B, and 1,000 from C to get his share of 3,000. Okay? Now, what if X alone goes after A alone? How much can he get? He can only get 1,000. Okay? And what if C is insolvent, no? Then the others are not liable to answer for his share. Why? Again, the debts are distinct from each other. Wala akong pakialam sa utang mo, sa share mo. Okay? So, if one of the parties is insolvent, the others will not answer for his insolvency. And in case one of the creditors makes a demand which interrupts the running of prescription as to one of the debtors, it does not prejudice the others because again, wala akong pake sa shares nyo. Okay? Final example, no? What if A and B bound themselves to deliver 1,000 sacks of rice to X and Y? But in this case, A and B delivered all the 1,000 sacks to X alone. Can Y still demand his share from A and B? Of course, because he did not get his share, no? Y may compel A and B to deliver 250 sacks each for 500 sacks, which is the share of Y. What is the remedy of A and B? They'll go after X for payment by mistake. Okay? Why? What's the reason here? Because the delivery by A and B to X of the full 1,000 sacks of rice did not extinguish their obligation to Y. So they still had to deliver the 500 sacks share of Y to him. Okay? And A and B will be liable for 250 sacks each because you divide that 500 into how many debtors there are. Okay? So, those rules that I talked about, those refer to joint divisible obligations. Okay? When we talk about joint or solidary obligations versus divisible or indivisible obligations, there is a very big difference. Okay? When we talk about joint or solidary liability, this refers to the vinculum juris or the legal tie. In other words, what is the liability of the parties? What is their relationship? Okay? So that's joint and solidary. But when we talk about divisible or indivisible obligations, we talk about the prestation. If the prestation is capable of partial performance or not. Okay? If the obligation is capable of partial performance, then it is divisible. But if it is not, then it is indivisible. Okay? So, again, the rules talked about earlier refer to a joint divisible obligation, meaning it's capable of partial performance. Now, there is such an animal known as a joint indivisible obligation, whereby the relationship of the parties are that they are still either liable for or entitled to only their proportionate share. But the prestation which they are bound to perform or receive is incapable of partial performance. An example of that prestation would be to give a car. You cannot give that car in pieces, no? You cannot be jointly liable for delivering only the motor and then the tires. No. That is an indivisible obligation, okay? So in this case, no, if the obligation is to give a car, the rule is that all the debtors together, in case they are jointly bound, must deliver it simultaneously, okay? And the creditors must all be present to collect or demand, okay? So, in this case, the creditors must proceed against all of the debtors at once, and the debtors must perform simultaneously. simultaneously. Okay? Now, what if one of the creditors refuses to accept? No? That's a big problem. Or in this case, the debtors, the joint debtors, will be justified in no longer delivering the car, and the remedy is simply to consign the car in court. Okay? If you want to learn more about tender and consignation, please just watch my episode on special forms of payment. Okay? Now, what if one of the joint debtors fails to deliver the car, no? Then, the obligation now will be converted into one for damages. Okay? Because they can no longer deliver the car. So now, it will be converted to a pecuniary liability for damages. So let's say the car is worth 240,000 and there are 3 debtors divided into 3. Each one will only be liable for 80,000. The one who refuses to perform will no longer be compelled to pay because he refused to perform, no? And the other 2 will simply pay their obligation of 80,000 to the creditors. Okay, without prejudice, of course, for the debtors, the co-debtors, to go after the party at fault for damages, no? Now, what if one of those debtors is insolvent, okay, or cannot pay? Are the others liable for his share? No. Okay? In which case, the creditor simply has to wait until that debtor is able to pay. Okay? So, those are the rules in joint indivisible obligation. Okay? However, I just have to warn you na just because an obligation is indivisible does not mean that there is solidary liability. That's different. And just because there is solidarity does not mean that the obligation is indivisible. That itself is a rule in the law. Okay? Because again, solidarity or joint liability for that matter refers to the legal tie or relationship among the parties. And divisibility or indivisibility refers to the prestation if it is capable of partial performance. Okay? Now, let's move on to solidarity, okay? Or solidary liability in an obligation. Okay, now solidarity may exist even though the creditors or the debtors are not bound in the same manner or for the same period or for the same conditions. Okay, so their situations may be different and it will still be a solidary obligation. Okay? So it's possible. But the general rule is that entire compliance may be demanded by the creditor and entire fulfillment may be demanded from the debtor. Okay? So that's the general rule. Okay? First, let's talk about the active aspect, no? There is active solidarity when the creditors are involved, okay? On the part of the creditors, there is active solidarity, which means that the creditors have a duty of mutual agency, okay? In other words, each creditor is treated as the agent of the other, okay? Also, in other words, the act of one is the act of all. But this only refers to acts which are useful, okay? This only refers to acts which a solidary creditor may perform which are useful to the others. Because if a solidary creditor performs an act which is prejudicial to the other creditors, then he may be held liable for damages. Okay? Such that first, solidary creditor cannot assign his right, no, without the consent of the others, no, because this is an act that is prejudicial to the other creditors. That creditor who will be assigning his right is introducing a party into the relationship that the co-creditors may not want to be partners with, no. So in this case, consent is required in case the solidary creditor will be assigning his rights. Also, in case of novation, compensation, confusion, or remission, no, or those modes of extinguishing an obligation, no. For more on that, please just refer to my videos on extinguishment, no. So in case of novation, compensation, confusion, or remission or condonation of the obligation, then these are in general prejudicial to the obligation, okay? Prejudicial to the co-creditors, in which case the creditor will be liable to his co-creditors. Because why did you do that, no? However, if it is beneficial to the co-creditors, then the creditor who caused the novation, compensation, etc. will only be liable to pay the shares properly due to the other creditors. Okay? So, speaking of that, no? Once a creditor receives full payment from a debtor, then the obligation is extinguished, okay? And there is now a duty on the part of the creditor under the mutual agency to now give the proper shares owing to each of his co-creditors, okay? That is what happens after the obligation has been fulfilled, okay? Now, any of the solidary creditors can proceed against any of the solidary debtors, okay? Or he can even go against any or all of them, no? And if a creditor does go against any of the debtors, then the debtor pays, of course, then the obligation will now be extinguished, okay? But in case the debtor which the creditor proceeded against was not able to fully pay, then the creditor is still allowed to go after the others until the obligation is fully satisfied, okay? So as long as the debt is not fully paid, the creditor can still go after the different debtors, okay? Now, what if there are two or more debtors who offer to pay? In this case, the creditor can choose, okay? But if a demand has been made by a creditor, then of course the debtor has to pay to that creditor who made a demand. Okay, so that's active solidarity, meaning solidarity on the part of the creditors, which gives rise to a mutual agency where the act of one creditor is the act of all creditors. Okay, let's go to passive solidarity, or solidarity on the part of the debtors. Passive solidarity gives rise to a mutual guarantee, okay, where each debtor answers for the debt default miscarriage of his co-debtors, okay? In other words, he is bound to render full compliance subject to claiming reimbursement of his co-debtors' respective share, okay? In other words, if one of the solidary debtors pays voluntarily or is made to pay, then the obligation is extinguished, and there is now a new obligation created amongst the debtors themselves, where they are bound to pay the debtor who paid the main obligation. They are bound to pay their respective shares only to the debtor who paid, okay? So again, the responsibility of the solidary debtors is for the entire obligation, but to their co-debtors only to the extent of the share after payment to the creditors. Okay? There's a new obligation, There's a new obligation amongst the debtors for reimbursement to the share corresponding to each of them. Okay? In case the debt has been paid after the due date, then the co-debtors are liable to pay interest. But if it was paid, if the obligation was extinguished before the due date, then the co-debtors do not have to pay interest to the debtor, okay? To the debtor who extinguished the obligation. Okay? Now, what if by acts of the solidary debtor, the obligation is condoned or remitted? Do the co-debtors have to pay that debtor who caused the remission or condonation? No, okay? There is no duty of reimbursement in this case. Why? The reason is simple. The debtor paid nothing. He just caused the extinguishment of the obligation, okay? So there is no duty to reimburse, okay? But if the remission or condonation only pertains to the share of that debtor, not the entire obligation, no? Then it does not relieve that debtor from paying his share or reimbursing his share to the others in case the obligation was fully paid before the remission happened, okay? Now, a solidary debtor who pays is not entitled to reimbursement if he paid it after the obligation has prescribed or has become illegal. Okay? Why? He's not entitled to reimbursement because he was no longer supposed to pay. If he pays something when it is no longer due, then he is not entitled to be reimbursed by his co-debtors. Okay? And what if the thing is lost? If the thing is lost without the fault of any of the debtors, then of course, the obligation is extinguished. Okay? Especially if it is due to a fortuitous event. Because under the rules on fortuitous events, in general, no one shall be liable in case of loss due to a fortuitous event. But, in case the thing is lost due to the fault of any of the Solidary debtors, or in case the thing is lost after the debtors are in delay and the thing is lost due to a fortuitous event, every one of the Solidary debtors shall be responsible for the price of the thing lost plus damages. Okay? But of course, after having paid the creditors, the innocent debtors can go after the guilty debtor for indemnification. Okay? Finally, let's talk about the defenses which may be raised by a Solidary debtor. Okay? There are a few. First, no? Solidary debtor can raise defenses which are inherent in the nature of the obligation, such as in payment or prescription, no? In which case, those are total defenses and he does not have to pay the obligation at all. Okay, whether for his share or for the full amount of the obligation. Because the defense is, wait, the obligation is extinguished because it has been fully paid or because the obligation has prescribed. That's a defense, okay? Second defense is he can raise those defenses which are personal to him, okay? Now, these defenses which are personal to him can either be total or partial defenses, no? Examples of total defenses would be minority or insanity, no? Those are just examples. There are others. So, in case a creditor goes after a debtor, the debtor can refuse to pay the full amount by saying, no, I can't pay, I am a minor or I am insane. Okay? And in case of partial defenses, the debtor may be subject to accidental elements, like it's subject to a suspensive, the obligation is subject to a suspensive condition. So that is a partial defense, okay? Now, third defense which may be raised, the Solidary debtor may raise the defenses which pertain to his own share, okay? So this is a partial defense because he is not absolved from paying the shares of the others, but at least he has a reduction as he can defend his own share. Okay, like one example, his share was subject to a period, no, and it is not yet due. So in that case, that's a partial defense for his own share. And finally, the fourth defense is those defenses which are personal to the others. Okay, this is also a partial defense, no? Such as when the debtor, Solidary debtor, claims the defense of minority of his co-debtor, no? As to that co-debtor, the one he is invoking, to that co-debtor, that is a total defense, no, of minority. That co-debtor cannot be made to pay the full amount. But if the debtor is invoking the minority of his co-debtor, then it's only a partial defense. This debtor can still be made to pay the share pertaining to him and the other co-debtors, but he can reduce or take out the share belonging to that minor. Okay? It's a partial defense. He will invoke the minority of that co-debtor and say, but he's a minor, so I'll just pay for my share and the rest, no? So that's what he is liable for. Okay? That's it for joint and solidary obligations. I hope you may have picked up a thing or two, and I hope to see you for the next video. See you soon. Bye!